Welcome to everyone who is trickling in right now. We're really excited here at the American Museum of Tort Law to be presenting Tort Law Educational Day. My name is Melissa Bird. I'm the director of the museum. The American Museum of Tort Law is located in Winsted, Connecticut, and we are dedicated to educate the public about the concept of tort law and its role in American society. The museum aims to shed light on the history and significance of tort law, which deals with civil wrongs and provides a means for individuals to seek compensation for injuries caused by others' negligence or misconduct. The museum features exhibits, artifacts, and interactive displays that explore various landmark tort cases and their impact on safety, justice, and corporate accountability in the United States. It serves as a thought-provoking resource for those interested in the legal system and its influence on consumer protection and public welfare. We are proud to sponsor this national educational event. Welcome to Tort Law Day 2023. We have a dynamic panel of esteemed speakers who will be speaking on the topic of the underutilization of tort law. Before we introduce our esteemed guests, I would like to take the opportunity to encourage all who are watching to visit our website, which is www.tortmuseum.org. Take a virtual tour. Also check out our online gift shop, which is stocked full of conversation starters and books, including David Engel's, one of our guests' book, The Myth of Litigious Society, Why People Don't Sue, which will be available on Monday. Our speakers today are David Engel, SUNY Distinguished Service Professor Emeritus of Law at the University of Buffalo, Pamela Gilbert, partner at Cuneo, Gilbert, and LaDuca, and Joanne Doroshow, founder and executive director of the Center for Justice and Democracy. I'm also joined by Ralph Nader, who is an activist, author, lecturer, and attorney. He has founded dozens of organizations, including Public Citizen, the Center for Auto Safety, the Center for Study of Responsive Law, and the American Museum of Tort Law. He has also played a pivotal role in advancing auto safety, consumer, and environmental protection laws. Today, I will be hosting this event, but first I'm going to turn things over to Ralph to introduce our topic. Ralph?
Thank you very much, Melissa Bird, and welcome to National Tort Law Education Day. Today, we describe a topic that's almost never discussed, the underutilization of tort law. The two private pillars of American law are tort law, the law of wrongful injury, that is, and contract law. They're called private in contrast to the criminal law and regulatory law because they are given to us, the people, to initiate. The government doesn't initiate tort lawsuits. Wrongfully injured people do, and they go to lawyers on a contingent fee to file their case in a public courtroom. No government agency initiates these lawsuits. They're initiated by the people. That's why they're called private pillars of law. The same with contract law. It's either initiated by a buyer or a seller, and they cut a deal. And once they sign, if somebody breaches it, in theory at least, the government supports the cause of the person who is breached to enforce the proper terms of the contract, which they now call terms and conditions on the internet, which are very one-sided, of course. But that's another topic. So we have here today three very experienced lawyers and scholars who've thought about why most people, the vast majority, don't use the law of wrongful injury when they believe they've been wrongfully injured. They'll present the world that leads to this phenomena called the underutilization of tort law, or not using your existing right, and how this underutilization harms the people, their society, and their government in terms of lost compensation, less disclosure of wrongdoing, and less deterrence against more wrongdoing by the perpetrators. So please listen carefully, learn, and then after the presentations, engage with our lecturers today with your questions or comments. And after the event is over, spread the word. It will be on our website, accessible from any place in the world in the coming weeks, months, and years. Back to you, Melissa.
All right, thank you, Ralph. Our first guest speaker today is David Engel. He is the SUNY Distinguished Service Professor Emeritus of Law at the University of Buffalo. He has published numerous books and articles about Asian and American legal cultures, as well as the effects of American civil rights legislation on men and women with disabilities. His book, The Myth of the Litigious Society, Why We Don't Sue, explains why, contrary to conventional wisdom, most American injury victims never lodge a claim against their injurers. Welcome, David.
Thank you very much, Melissa. I'm really happy to have the chance to join this important program, and I'll also try to be short, sweet, and relevant. So why do so few Americans use tort law when they've been injured? That may seem like a ridiculous question. The conventional wisdom is that Americans are the most litigious people on earth. When we get injured, supposedly we sue at the drop of a hat. The problem is that the data just don't support this view. We now have a number of studies that show that when people experience personal injuries, fewer than 4% consult lawyers, and somewhere around 2% actually bring lawsuits. And those are probably overestimates. That doesn't seem very litigious by any standard. The research is quite convincing, but it doesn't tell us why Americans are reluctant to use tort law. How can we explain why so few people invoke their rights, even when they've been injured, in a way that seriously affects their lives? So I've been looking for answers in a lot of different fields, such as psychology, sociology, neurology, rehab science, nursing, even anesthesiology. You can see I wandered pretty far afield to search for answers. But I did find at least 5 reasons that help explain why we don't sue. Now, I won't be focusing so much on the handful of folks who actually do go to see a lawyer. I definitely won't be talking about high-profile injury lawsuits. Instead, I'd like to consider ordinary people at the moment they've been hurt. What do they think? What do they do at that moment? And what do they do in the days that follow? Well, we tend to overlook one of the most obvious reasons why most injury victims don't pursue a claim. Many of them are in pain and they're receiving medical treatment. These are not the clear-minded, rational actors who carefully weigh risks and benefits before they decide whether it's worth it to use the law. Pain medication, they fog people's thinking and their speech. Pain saps their energy, and pain isolates them socially from folks who could offer advice and encouragement. So maybe we haven't thought enough about the fact that injuries can be debilitating, sometimes long-term. Pain and disability, just by themselves, could be one big reason injury victims don't take the initiative to bring claims against their injurers. But there are other reasons too. Before people decide to pursue a claim, they have to recognize that something out of the ordinary, something wrongful, has happened to them. If they see their injury as normal or natural or unexceptional, they're not likely to think in terms of tort law at all. The normalization of many injuries turns out to be a major reason why most people don't pursue claims. For example, falls on stairs account for 1 or 2 million injuries each year and thousands of deaths. Many of the victims are older people. These accidents are generally seen as a natural feature of stairs. They're normalized. But safety engineers and ergonomic specialists don't agree that falling on stairs is a normal or unavoidable risk of life. They found that stairs can actually be designed to minimize the chance of falls. The failure to adopt a safer stair design could be a tort, but injury victims almost never see it that way. After the accident, their common sense tells most of them that falls on stairs are not a reason to blame anyone, except maybe the person who fell. So the normalization of risks applies to a lot of injuries that accident victims might view as tortious, but usually don't. I'm sure we could come up with a number of products whose risks seem normal to the victims, even though the manufacturers could adopt a safer design. And maybe we can discuss some of those in the Q&A. Another reason injury victims don't turn to tort law is closely related to normalization, and that's the problem of causation. Of course, many injuries result from causes unknown, such as chemical dumps or toxic leaks. The victims don't consider using tort law. They don't even consult a lawyer because they don't know why they've become ill. They don't see anyone there to blame, no causal link to a potential defendant. But even when people understand why and how they've been injured, their views of causation may lead them not to sue. Ordinary people don't think about causation the way lawyers do. Ideas about the but-for test or proximate cause don't guide their thinking much at all. Why do bad things happen in the world? Why did I become ill or suffer physical harm? For some injury victims, it's just bad luck, like losing the lottery. But for many others, the root cause was fate or God's will or karma. This kind of thinking about causation is extremely common. Many injury victims conclude that it makes no sense to hold another person responsible, even if they satisfy the but-for test. In fact, it may be sinful to lay the blame on someone else for what was part of the divine plan. Social norms and religious beliefs shape people's views about causation more than tort doctrine does. These popular views of causation lead us to a fourth explanation for why we don't sue, and that's self-blame. It's very common, of course, for other people to blame the victim when injuries occur. Even more striking, though, a large number of injury victims also blame themselves. In fact, I've become convinced that self-blame is one of the most common reasons why tort law is never considered by most injury victims. Sometimes self-blame is related to religious beliefs. Injury victims think they suffer because of sins they committed. Pain is punishment. But self-blame isn't necessarily religious. Even non-religious types very often feel that they could have avoided harm if they'd been just a little more careful, or if they'd looked after their child just a little better. Self-blame is remarkably widespread. On top of that, victims tend to feel that their own blameworthiness supersedes the fault of the injurer. They don't think in tort law terms about comparative negligence. They feel that if they're at fault, that's a total get out of jail free card for the injurer. Self-blame makes it wrong for them to pursue any compensation at all. The last factor I want to mention is our culture, which tends to denigrate injury claims and ridicule tort plaintiffs and their lawyers. Now, injuries tend to flow down the social hierarchy. They disproportionately harm people with lower socioeconomic status. But cultural production occurs at the top of the social pyramid. Those at the top are in the best position to create an injury culture that normalizes injuries and vilifies plaintiffs. The creation of an anti-tort law culture in the 1980s and 1990s has been well documented, and I think we'll be hearing more about attacks on the civil liberty system today. But even in a culture biased against tort law, we might ask why most individuals don't swim against the current when they've been harmed. When people find themselves in desperate circumstances, or when they feel outraged by the behavior of their injurers, Why don't they think in terms of bringing a claim? Well, one answer is that many injury victims have bought into these negative social norms. They're convinced that it's just wrong to hire a lawyer. They'd never bring an injury case, no matter how compelling the facts might be. As one small business owner told me, we don't do that. But some injured people might want to bring a claim, yet they choose not to. The reason is that their highest priority is not to assert their rights, but to maintain their position in a particular social group. For them, the motivation to belong is stronger than the motivation for justice. Many injury victims just want to stay a member in good standing in their family, in their neighborhood, in their workplace, in their church or temple, or in their community. To invoke tort law would mean social death. One woman who lived in a small community told me her daughter was killed by a negligent driver. She did consider suing, but she realized that if she hired a lawyer, she and her husband would have to move away. She didn't want to leave town. She wanted to stay near her daughter's gravesite. To remain a member of the community, she had to give up any thought of using tort law. So to wrap up, for many injury victims, it's not a cost-benefit analysis that leads them away from tort law. They don't even make a decision. The forces of normalization, self-blame, the desire to belong, they simply remove tort law from the equation for most injury victims. Very often, the possibility of tort law never even rises to the level of conscious thought. It's eliminated in the fast pre-conscious cognition that guides us in our lives. So these aren't the only reasons we don't sue, but they're some of the most important ones. Thanks for your attention. I look forward to your questions or your comments.
You mentioned anesthesiology. I have to ask, what went on? What went on there?
Well, I learned a lot as I did my exploring, and one was that the study of pain turns out to be a specialty of anesthesiologists. They have a journal called Pain, and some of the most interesting articles I found were actually in that journal, talking about the effects of pain on cognition and on decision making, and also the effects of pain on people around the injured person. One thing we don't think enough about, I guess, is the ripple effects of injuries, even in ways that tort law couldn't provide recovery for. Caretakers suffered a disproportionate number of illnesses and even death because they're caring for someone who suffered an injury themselves.
How does one find an efficacious tort lawyer willing to take the case?
Well, that's a question that some of my fellow panelists can probably ask as well. But there are studies that show that simply going to a lawyer in those roughly 4% of the cases doesn't mean that a claim is going to be filed. Actually, about 2/3 of the people in one of the studies by Bert Kritzer, that 2/3 of the people who approached civil attorneys about an injury claim were actually turned away, sometimes for good reasons and sometimes because of questions the lawyer had about their own ability to represent, or because they thought the plaintiff for some reason wouldn't be an attractive plaintiff, or because the returns wouldn't be high enough for the lawyer.
Hi, I'm currently studying for a paralegal certificate, and just last week in my new case law or contract law class, we did a case study that was based on a civil tort suit, and immediately my cohort attributed negative or malicious intent on the part of the plaintiff, but not even a question on the part of the defendant, who is a corporation. And I spoke out about this, but I didn't have any kind of knowledge of law or a good retort, except to point out that it seemed like bias and unfair to attribute negative motive and intention on the plaintiff and not equally look at the possibility of that kind of motive being on the defendant company as well. What kind of laws protect a plaintiff in a court trial or hearing against that kind of bias? And what kind of retort would you suggest?
Well, I think you're providing more evidence that the culture wars of the 1980s and 1990s went very well for the defendants and for the people who inflict injuries, and not well at all for those who suffer injuries. And I went the whole talk without mentioning the McDonald's coffee case, but that was a sort of emblem for the tort reformers. The facts of that were incredibly distorted. It was a reasonable type of tort action to bring. You might want to mention that to your classmates, that case, find out the real facts and describe them to your classmates and ask them what they think about it. But I would say, in our culture, we have sort of conflicting images of tort plaintiffs and tort lawyers. There are portrayals, Hollywood portrayals, that are favorable to the idea of bringing a tort claim, the sort of heroic lawyer, the search for justice by the injured person, Aaron Brockovich, and so on. But then there are the other kinds of portrayals that show, Whiplash Willie and the people that are trying to rip off the system. So we have these sort of two different ways of thinking about tort plaintiffs and tort lawyers in our culture. It's just that around that time in the 80s and 90s, the balance tipped drastically in favor of the negative portrayal. And it takes some effort to convince people that there's another side to the question. Also, for what it's worth, when I was still teaching tort law, I did a survey of my students on day one of the class and asked them how often they thought injured people actually brought tort cases and what they thought about them. And these were law students who came with the most negative views of tort law initially. And gradually, as they learned more about it, their ideas began to change.
So this is Pamela Gilbert. Can I jump in?
Please.
Hi, David.
Hi.
Nice to see you. Yeah, because I just want to say that not a coincidence, though, that there are these negative feelings about bringing lawsuits. This is partly a result of a multi-million-dollar, if not multi-hundred-million-dollar campaign by the business community and the Chamber of Commerce and other large mega corporations to deter people from bringing lawsuits. And I'm going to talk a little bit about the results of some of those campaigns. But so it didn't happen naturally. This is really the result of misinformation coming out again and again and again. The McDonald's coffee case is a perfect example, but a lot of examples that other people hear about were actually completely made up. The McDonald's coffee case did happen, but the facts were misrepresented in a gross way. And so people became very, very skeptical of that lawsuit. But there are other cases that were made up out of whole cloth that we would see over and over and over again as examples of crazy cases. And so it is something that, we need to the extent we can, one-on-one, try to rebut those claims that so many people sue. Too many people sue. There are so many frivolous lawsuits. And so, David, the work that you do is very important. And we need to continue to do that.
I worked many years in medical mal plaintiffs and personal injury. So, I'm always with my adversaries talking about the bar. And for every case I would have, they would tell me of the frivolous one. So what I'm interested to know is the data. If you have this 4% figure of people who are injured actually on such a small amount to sue, any statistics on how many meritless are thrown out?
Yes, there's actually a study that I love to cite. It's been around for a while now, but it was specifically on using medical malpractice cases as an example. The problem with determining how many cases are brought to a lawyer, how many actually are filed, is that we can't tell for sure how many were meritorious and how many were not. But in this study, it was a beautiful study because he found several databases that consisted of medical malpractice claims that had actually been vetted by insurance companies and were classified as meritorious or not meritorious. This is a study by Michael Sachs. And then he was able to look at what happened to the meritorious cases. And it turned out that the figures were just about the same, that about 4% of the meritorious cases went to lawyers and about 2% were actually filed as lawsuits, which is pretty remarkable when you think that when you think how many valid cases actually dropped out along the way and never became claims that were that entered the tort law system. I think that study might be of interest to you. Other studies look at just injuries in general, not necessarily medical malpractice injuries, mostly accidental injuries, and they trace what the injury victims did after they were hurt and how many of them sought some kind of relief and how many actually entered the legal system. And the numbers were about the same as in the study that I just mentioned dealing with medical malpractice.
Okay, our next guest speaker is Pamela Gilbert. She is partner at Cuneo, Gilbert, and LaDuca. She is one of the leading advocates in Washington, D.C., working to protect consumers, preserve access to the civil justice system for both individuals and businesses, and ensure that Congress does not provide immunity to the fossil fuel industry for its deception campaign about the climate crisis. Welcome, Pamela. We're excited to have you.
Thank you so much, Melissa. And it's great to be here. And hello to everybody out there. It's really a pleasure to be here. So, David, thank you for that. That was a really interesting talk that you just gave. And so now I'm going to talk about that small 4% that actually maybe try to bring a case and go to a lawyer, and a couple of the obstacles that are in the way of then bringing a successful lawsuit in the U.S. And I do have notes, so I'm going to be reading. So as we've heard and folks on this call know, the U.S. civil justice system allows people to seek redress for legal wrongs that have been done to them, and it is in fact envied around the world for its open access. It doesn't guarantee an outcome, but it gives you your day in court. And it is, as Ralph said, it's the one place that is not controlled by the super rich, the mega corporations, their lobbyists, or politicians. It's the one system that isn't rigged. And I'm going to add, for the most part, because now we're seeing recent revelations about exorbitant gifts to Clarence Thomas and other Supreme Court justices that may indeed be rigging the system, but it's not the topic for today. So it shouldn't be a huge surprise that mega corporations and their trade associations have been trying for decades to block access to the courts, the one place that moneyed interests don't control. So there are numerous ways that they've been trying to do this over the years, but I'm going to today focus my remarks on one of the biggest obstacles to bringing lawsuits that we are confronting today, which is called forced arbitration. And if there's more time, I'm also going to talk about the doctrine of federal preemption, which is also getting in the way. So arbitration refers to alternative dispute resolution process that takes place in a private forum instead of a courtroom in front of an arbitrator who's usually the final decision maker. And it actually can be a perfectly fine way to resolve a dispute if parties of equal bargaining power agree to arbitrate a dispute with full knowledge and information. What I'm going to talk about is forced arbitration, which is something really entirely different. And forced arbitration clauses are inserted into the fine print of terms of service and contracts that are written by corporations for the benefit of corporations. They are found in most consumer transactions and most employment contracts. Consumers and workers who are subject to these clauses have no ability to negotiate or change the contracts. They're take it or leave it. The clauses require that any dispute between the consumer or the worker and the corporation cannot be resolved in a public court. They must go before an arbitrator in a secret proceeding, and the claimant, most of the time, the claimant must proceed on his or her own. You can't join together with other people who might have suffered similar harms. And the arbitration provider is usually chosen by the corporation. In addition, there are no rules of discovery or evidence in arbitration. The rules are whatever the arbitration company and the arbitrator say they are. There's no right to appeal, or very limited right to appeal. And the arbitrators have to be paid, and sometimes it costs thousands of dollars. So, not surprisingly, corporations almost always win in arbitration. One study by the Consumer Financial Protection Bureau found that companies win over 90% of the time in arbitration. One big reason is that the corporations are repeat players in the system. So there's an incentive, of course, on the part of the arbitrator to please the corporation, so they will be hired again. Consumers and workers, it's usually a one-off. And so there's no incentive on the part of the arbitrator to rule in their favor. Unfortunately, forced arbitration clauses are ubiquitous. You can find them in terms of service for cell phones, cable service, credit cards, bank accounts, prepaid cards, car sales and loans, nursing home agreements, private student loans, car share services, Airbnb, et cetera, et cetera, et cetera, et cetera. Also, according to studies, over 50% of workers are bound by forced arbitration if they want to sue their employers. So each and every one of us are subject to multiple forced arbitration clauses as we sit here today, even though you may or may not be aware of it. So it means that if you get in a dispute with any of those companies you're doing business with, you are shut out of the public court system that was established, in the Constitution. You'll be forced to go it alone in a secretive rigged system that's controlled by the corporation that you are suing. Sounds kind of un-American, and it sounds kind of unconstitutional, but unfortunately, this has been the forcing consumers and workers into arbitration has been upheld time and time and time again by the U.S. Supreme Court and courts underneath the Supreme Court. So it is, unfortunately, right now, the law of the land. I'm going to give you a couple of examples just to show the huge unfairness in using forced arbitration. First, I'm going to take a drink of water. So one outrageous use of forced arbitration came recently, relatively recently, with Wells Fargo Bank, which, if you follow this at all, Wells Fargo has been in trouble for a host of scandals and fraud. But one of the biggest ones was it was discovered that Wells Fargo had opened millions of fake accounts on behalf of their customers. So you might have an account with Wells Fargo, and they would just go in there and have you open another Wells Fargo account without you knowing at all. But that would result in fees if the account came with fees to you. And then if you didn't pay those fees, a lot of people's credit scores were ruined. And this happened in the millions of people. So when the bank's customers found out about it and tried to group collectively in a class action and sue Wells Fargo, Wells Fargo used forced arbitration in its legitimate accounts. And so all those customers that had otherwise legitimate accounts with Wells Fargo wanted to sue Wells Fargo for the fake accounts, and it was ruled that they couldn't. They were forced into one-by-one arbitration because of the arbitration clause that was in their legitimate account. This is just a wide open door for a company to pursue egregious fraud with a get out of jail free card, because in that one place they had bound the customer to forced arbitration, because most of these clauses are written to say any dispute you have with the company. So any dispute you have with the company, you have to use forced arbitration, even if the dispute involves outright fraud about something that you didn't know anything about and you were the victim Another equally outrageous example deals with a woman, I'll just use her first name, Lily, who was sexually assaulted by a massage envy therapist. So you can imagine that after this very, very traumatic experience, Lily didn't want to have anything more to do with Massage Envy and wanted to cancel her account, her subscription with Massage Envy. She tried to do it over the phone, and she just kept being told that you have to do it through the app. You cannot cancel unless you download the app and then cancel through the app. So she thought, all right, it's a pain in the neck, but I'm going to do it. She downloaded the app, and in downloading the app to cancel her subscription because she'd been sexually assaulted, she was automatically bound by a forced arbitration clause. So then when she turned around and tried to sue Massage Envy, and by the way, Massage Envy was accused of having many employees that had participated in sexual assault against their customers. So Lily was one of many trying to sue the company. But if you had downloaded their app, you were in forced arbitration. And so instead of going to a public court to accuse and to litigate against Massage Envy, Lily was forced into arbitration, again, one by one. And one of the really awful things about that is that, in a case of sexual assault, if you're willing to be the one that's going to sue the company to deter this kind of conduct, you want the public to know, because that's the only way that Massage Envy is going to start policing who their employees and overseeing them and monitoring them to make sure that this doesn't happen again. But if they can sweep it under the rug one by one in secret forced arbitration, there's no harm to their reputation, and the conduct can continue. And none of this sounds like it's right. And how can courts be ruling this way? But unfortunately, the law that has evolved around forced arbitration doesn't make a lot of sense and is extremely unfair, but it is what it is. So bottom line, forced arbitration provisions give corporations the power to funnel the cases of workers, consumers, investors, and small businesses even into private secret tribunals, which are designed by the corporation to be so rigged that it amounts to virtual immunity for the corporations. Americans are left to suffer in silence while corporations continue to violate the law with impunity. And because forced arbitration, as I said, is secret, there's no public filing of cases, and there's no incentives for the corporations to follow the law in the future. So that sounds pretty depressing, so I'm going to try to end on a little bit of a high note here. There are some bright spots on the horizon for forced arbitration, mostly because this is so outrageous and so unfair that there are groups of advocates, labor unions, workers who are now beginning to rise up and say that this is not okay. So very happy to announce that last year, a bill called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act passed Congress and was signed into law by President Biden. And the law allows survivors of sexual misconduct to sue in open court rather than being forced into arbitration where the claims are secret and the person making the claim is at a great disadvantage. And the other really nice thing about this bill, it passed the House of Representatives on a strong bipartisan vote, 335 to 97. And in the Senate, there were no objections. It was voice voted. So while it was only on this issue, it's an important issue of sexual harassment and sexual assault, it did establish a precedent that we are going to try to use, that politicians and public officials on both sides of the aisle do understand that sometimes forced arbitration is really entirely unfair and inappropriate. And we're going to try to use that precedent going forward in other areas. There's what we call the big bill, which is called the Forced Arbitration Injustice Repeal Act, or the FAIR Act, which has been introduced in multiple Congresses. And that one, if that passed, it would address almost every circumstance where consumers and workers are forced into arbitration. So the FAIR Act prohibits the enforcement of forced arbitration and consumer employment discrimination and antitrust lawsuits. It has 95 co-sponsors in the House and 37 in the Senate, so it has some broad support, much more on the Democratic side than on the Republican side at the moment. But we have a large coalition working on that bill, and we have hopes for it in the future. And finally, the Consumer Financial Protection Bureau, the CFPB, is currently considering a petition that was filed by consumer organizations requesting the agency to enact a rule against forced arbitration. So what the petition is asking the CFPB to do is to say that arbitration can only be used in a dispute with a financial services company if the arbitration is agreed to after the dispute arises and completely voluntarily by the claimant. So what happens with forced arbitration is you're signing a terms and conditions when you have no idea at all that you're going to be harmed by the company you're going to be dealing with. So you don't know about the forced arbitration clause, you don't care about it, you don't think about it, it's not relevant. It becomes relevant when you're harmed, when you're injured. And so what this rule would do, if the CFPB takes it up, would say that's when you go to the consumer and say, now that you've been injured, would you rather proceed in arbitration or would you rather proceed in court, and give them the choice, which is much fairer and makes much more sense. So there is a growing chorus of consumers, workers, and students have gotten very involved in this issue around the country, demanding an end to forced arbitration. It will unfortunately take an act of Congress to put an end to this unfair rigged system, because the court rulings have been so negative. So we really can't do it in court, and you actually can't do it on the state level either, which if there are questions, I can respond to them. So that's arbitration. I don't know, Hannah and Melissa, should we stop there and take questions, or time for federal preemption? I can go either way.
Should we start with some questions and then see where we land? I find myself just getting wound up listening to you, like how angry. Do you have ways?
I am too.
Do you have ways that regular citizens can get more involved to combat this type of thing? I mean, I think students on college campuses, find themselves in an easier position to become advocates for different things.
Sure. So I did mention that students have gotten involved. So one bright spot were there are law students at particular law schools, and it started at kind of the elite law schools where the students who are graduating are very, very much in demand. And they have put out petitions to the law firms that are seeking to hire them to say that I'm not going to come work for your law firm unless you dropped your forced arbitration clauses against your employees, or if they're going to work for a company, likewise, that you need to drop your forced arbitration clause. I will also say that there have been walkouts by employees over the issue of forced arbitration, most particularly at Google. And Google was forced by their own employees to take their forced arbitration clause out of their employment contracts. So there's beginning to be public pressure. And then there's another strategy, I should say, that's being used by some law firms around the country. And they are taking widespread corporate misconduct, when it's like the Wells Fargo thing, when you are affecting thousands, hundreds of thousands, if not millions of individuals by your bad business practices, whatever they are. There are companies that are using the internet to find the individuals that have been harmed and signing them up one by one to go to arbitration. Well, usually in these forced arbitration clauses, the companies agree to pay the arbitration fee because they know it's sort of unfair to make a consumer pay the $10,000 it costs to actually even start the arbitration. So the companies know no one's going to go to arbitration. So they say, sure, we'll pay the $10,000. But when 1 million people are asking you to pay $10,000 a shot, that is a lot of money. And the companies, this is so ironic, in those situations, the companies are going to court and saying they can't arbitrate, those people need to be forced to go to court. because they don't want to pay for the price. So, which really shows that forced arbitration is all about suppressing the claims as opposed to going one by one in arbitration. And so that technique was applied against Amazon, and Amazon has dropped their forced arbitration clauses against consumers because they can't afford it.
Yeah, that's light at the end of the tunnel.
So there are things that individuals can do.
Hi, thanks for the second opportunity. I am wondering how forced arbitration and the trend towards forced arbitration affects workers' right to strike. I'm particularly thinking about Biden's response to the rail workers' strike and the forced contract and prevention of those workers from striking. I know that forced arbitration would affect their ability to get a contract, but how does it affect specifically workers' rights to strike? Thank you.
Yeah, so Laura, that is a great question. So if you're in a labor union, you are most likely protected from these kinds of forced arbitration clauses. That's another great advantage of being represented by a union. So unions do negotiate contracts, and they sometimes negotiate arbitration between the workers and the company. But this is what I said at the beginning. Arbitration isn't necessarily bad as long as the parties actually negotiate for it and they know what they're getting into, and the workers have a reason to want to arbitrate and the companies do, because litigation can be expensive and lengthy. Sometimes arbitrating disputes is the better way to go. And so labor unions, because they actually negotiate contracts, usually protect workers from these forced arbitration clauses. It's so unfortunate that so many workers are not protected by unions, and that's why we have the prevalence of forced arbitration that we do.
Our next question is from Stephen Weisensale, but their microphone isn't working, so I'll read the question. There's two questions. I think the second one is a little bit more relevant to this portion of the discussion. About 6 or 7 years ago, Johns Hopkins completed a study that showed that in any given year, 250,000 people died from medical mistakes. What happens to those 250,000 cases of medical malpractice? How many are filed as torts? And this might be a little bit more narrowly relevant. Another question: in going into major surgery, do people have to agree to forced arbitration?
So these are great questions. A tiny percentage of that 250,000 people ever file medical malpractice claims. I don't have a number, but it's going to be, just like David said, it's going to be a very small, single-digit percentage that file claims. And medical malpractice claims are actually very, very difficult to win in court. Suing a doctor, it goes back to this whole mentality of, the doctors don't usually make mistakes, and also you have a real imbalance of information. You're the patient, they're the doctor. If you were in surgery and you were under, anesthesia, it's very, very difficult to prove what went on in that room and how the negligence occurred. So medical malpractice cases in particular are extremely difficult to bring and win, and the vast majority of people don't bring those cases. But on forced arbitration, historically, we haven't seen forced arbitration, in healthcare settings, but now now we're beginning to see it. And so I would really recommend to people that if their doctors are giving you forms to fill out, read them very carefully. And to the extent you can, tell them you do not want us. If there's forced arbitration agreement in there, try to exit out and not sign on to that. And the same thing in hospitals. If you sign, hospitals may be using forced arbitration. There's nothing in the law that says that they can't. I mean, there's nothing, that makes an exception for life or death or hospitals, like things that you would think that we really need protection. Forced arbitration is pretty much fair game almost everywhere. There are some exceptions in the law. So again, if you're signing paperwork to go into a hospital, look for a forced arbitration clause, and while you're signing it, try to see if you can tell them you won't sign that part of the contract. And I'll just throw in, nursing homes are notorious for using forced arbitration in their applications, but by law, if they're taking any federal money, they are not supposed to have it be a condition of applying and being admitted to that facility. So you are within your rights in a nursing home contract to X that out and say you won't sign it. But they do put them in there.
Awesome. Pamela, do you think you have just a couple minutes to run over the preemption before we close up, or do you
Sure,
think
let me just
like
sort
a
of
super brief?
say what it is. I won't read what I've prepared. But so another way that corporations had tried to get out of their state tort liability, most tort law, most personal injury law, these are state laws. And so what companies want to do is pass federal laws that override your state law rights to go to court. And you see that most in the regulatory arena. So when there is legislation to regulate the safety of automobiles or pharmaceutical products or consumer products, there are efforts both in the law, and then they make efforts in court as well in interpreting the law to say that if it's a regulated product and that product meets the federal standards, then you can't sue us at all, no matter what we did negligently, no matter how badly you were injured. And as the courts have gotten more conservative, those preemption arguments have been accepted more and more. And I'll just give you one example just to show how it doesn't make any sense. In 2009, there was a case that came before the Supreme Court about a brand name drug. Everybody knows that there are brand name drugs that come on the market and they get patent protection for a certain period of time. And then when that patent protection is over, generic drugs come on the market when the price drops significantly. So brand name drugs, a brand name drug was sued in a case, and the issue of whether the federal approval of the brand name drug would preempt that lawsuit went all the way up to the Supreme Court. And to the Supreme Court's credit, they said no. The approval of that drug does not say that there's nothing that the company could do negligently that could injure somebody so that they should be compensated, even if the drug obtained approval. And so they did allow, and it's true today, that you can sue a brand name company if it injures or harms you in some way. Not too many years later, the same similar fact pattern went up to the Supreme Court for a generic drug. And the court ruled there is federal preemption for a generic drug. So even if it's the same drug, right? Like years later, it loses its patent protection. And so now it becomes generic. You can't sue. The court's rationale for that is that generic companies don't control the label and the marketing of the drug like the brand name companies do. And so it would be unfair to sue the generic company. So and there have been efforts to change that, but that's how the law stands now. And it's incredibly unfair. And most of us take generic drugs way more than we take drugs that are protected by patents. And so we are locked out of the courtroom because of that decision. And I'll leave it there.
Thank you, Pamela. I'm going to introduce our next speaker, Joanne Doroshow. She is the founder and executive director of the Center for Justice and Democracy and co-founder of Americans for Insurance Reform. She is also an adjunct professor at New York Law School, where she teaches congressional, consumer, and civil justice. As an attorney, Doroshow has worked on civil justice issues since 1986. She also directed an insurance industry and liability project for Ralph Nader. Welcome, Joanne. We appreciate you being here today.
Thank you so much, Melissa. Great to see everybody from the US and from around the world participating today. in this really important discussion. As Melissa mentioned, I'm the executive director of the Center for Justice and Democracy, which I actually created in 1998 to fight attacks on the civil justice system. Some call those attacks tort reform, or as Ralph likes to call it, tort deform. There are restrictions on the tort system, limits on the tort system. I'll use various types of ways to describe these laws. The same year that I formed the Center for Justice and Democracy, 1998, also happens to be the very same year that the U.S. Chamber of Commerce, which is the largest corporate lobby group in the United States, formed its branch to attack the rights of people to go to court. And that group is called the Institute for Legal Reform. And 1998 might seem a long time ago, but actually all this political activity around the tort system and how people can access the courts, the civil justice system, kind of started close to 50 years ago, I would say. And it all started with the insurance industry. And when I say the insurance industry, what I'm really talking about is the property casualty insurance industry. That's different from life insurance. It's different from health insurance. Property casualty is covers your auto insurance, property, homeowners. It also covers businesses for liability, including small businesses, but also big businesses, manufacturers, product liability type insurance. And it also covers professionals like doctors and coverage for medical malpractice, which we've talked a little bit already about today. And as Pamela mentioned, tort law is state law. This is the system that develops the tort laws that currently exist today, whether by judges and juries or by statute. And in addition, insurance is regulated at the state level in the United States. So most of the activity around limiting victims' rights was and continues to be primarily, excuse me, at the state level, where state legislatures and governors have a lot of control, as well as state regulators like insurance regulators. So what is this whole tort reform, tort deform thing really about? And I think you've kind of heard a lot today about this already. It's basically corporate lobbyists want immunity for their members when their members kill or injure people due to negligence or other kinds of wrongdoing. Insurance companies want to hold on to their money. They don't want to pay claims. Hospitals and those who are engaged in grossly negligent healthcare, where patients are injured or even killed, they don't want people to know about this. And they also don't want to be sued for it. So these corporations, the insurance industry, and professional organized medicine, like the American Medical Association, join together and they try to lobby for laws that strip individual everyday people of their legal rights to sue and also to be properly compensated. Now, before the sort of the mid-1970s, I would say consumer rights organizations, I mean, Ralph can correct me on this, but to the extent consumer rights organizations even existed back then, they didn't focus a whole lot of time or energy on the tort system. Because really until then, until the 70s, this system had operated generally without a lot of political interference. But that all changed in the mid-1970s when the nation was hit with what was then and now known as the first liability insurance crisis. All of a sudden, rates started going up for doctors and small businesses. Policies started getting canceled for no reason. Nobody could figure out why this was happening, but the insurance industry quickly blamed, without any evidence at all, lawyers and litigation for their need to raise rates like this. And lawmakers were being told that the only way to bring down rates and to ease this crisis was to strip away the legal rights of patients and other consumers. They never asked for any evidence or data to prove this law. They just started, the industry started telling lawmakers, this is what you have to do. So between 1975 and 1977, I would say, half the states at that point took away some legal rights of patients and other consumers. And the data shows there never was a litigation explosion back then, but it didn't matter. The political lessons learned by the insurance industry and corporations were clear. By blaming lawyers and litigation for a crisis that the industry itself had manufactured, they could obtain major changes in tort laws to reduce or eliminate legitimate claims. And remember that these laws have nothing to do with frivolous lawsuits. These are laws that take away the rights of everybody, no matter what kind of case, all claims, all lawsuits, legitimate or not. Now, historically, what happened then is insurance rates stabilized for about 10 years. So nobody was talking about any of this for about a decade. Then all of a sudden, 1985 happened. And suddenly the country was in a new insurance crisis. Small businesses, doctors, nonprofit groups were all being hit at the same time. Dramatic rate increases, arbitrary cancellations of policies. Here we are again, another manufactured insurance crisis. And that's when I would say the so-called tort reform movement really took off. It was in the midst of all this in January of 1986 that a new organization formed called the American Tort Reform Association. These were largely Fortune 500 companies with a direct financial stake in limiting lawsuits. And they were tobacco companies, insurance, oil, chemical, pharmaceutical, auto manufacturers, all the big industries were part of this. And it just so happens that this was the period of time when Ralph asked me to first help push back on these attacks on the civil justice system. I went to work for him in his office to do this. And for the next 3-4 years, we were, there was a lot going on at the state level to try to push back. Nearly every state during this period passed some kind of legislation to limit people's rights to go to court. Some worse than others. Then things died down again. Third crisis then hit the country again, 2002 to 2006. Again, at least half the states responded to the insurance industry by passing some kind of tort restrictions. And it just so happens that we are in the middle of a fourth such crisis right now. It's not as bad as some of the prior crises have been, but the insurance industry is trying to take advantage of it where they can, particularly where there are weather-related and climate catastrophes, such as in Florida, where the legislature is moving quickly to take away people's rights to sue insurance companies over denied or lowballed claims. So this keeps happening. Now, insurance companies are never forthcoming about why these crises happen. If you want to understand a little bit more about the insurance industry and how it works, we did a great little manual, which you can find at a website called insurancefatcat.com. It's an essential guide to understanding insurance. I'm not going to go into the details of how this works now because it will take a couple hours, but that little manual can help explain things for you. But the reality is that state lawmakers never demand to see data, insurance data or litigation data. All they hear is one side from the insurance company, and then they go ahead and pass these laws. And history shows that it kind of never works. We've done many reports showing that premiums never go down after these laws passed. And I know that, I need to wrap up on time here, but so let's just talk very briefly about what kinds of laws we're talking about, some of the most common tort restrictions that we see at the state level. Caps on damages. Caps are an arbitrary ceiling on the amount that a judge or jury is allowed to award in a case, irrespective of what the evidence is at trial. So caps also they not only hurt victims, but they also take away the authority of judges and juries. Caps on non-economic damages are extremely common. These are the kinds of injuries like permanent disability, loss of a limb, disfigurement, loss of a reproductive system. Caps on punitive damages are also very common at the state level. Punitive damages are only assessed in rare situations of particularly egregious misconduct. But of course, corporations want those capped, so they are considered more or less a cost of doing business. And then one more I'll just mention briefly is, because it's come up in discussion, this contingency fee system, how injured people are able to access the courts. A lawyer agrees to take a case without charging any money up front. They will take a percentage of a case only if they win the case. So there's a big risk that a lawyer taking a case on contingency may end up with nothing if they lose the case. But they usually typically take a third. This is what a system that provides access to the courts for many people. And of course, the corporate lobbies have passed laws to restrict contingency fees, making it more difficult for people to actually hire their own lawyer. So with that, let me just wrap it up by saying Pamela tried to give a little sort of optimistic note about arbitration. I'll say the same thing about tort issues. Many states haven't done terrible tort restrictions. Some have, but others haven't. And many states' Supreme Courts have struck some of these down as unconstitutional. There's also recent polling from the American Association of Justice of people believe increasingly in the jury system, the civil jury system, and its importance. And it's one of the reasons why you don't see tort restriction proposals coming from Democrats. Typically, you see them from Republicans, but not every Republican. A lot of Republicans believe strongly in the local jury system and accountability, and it's one of the reasons why we haven't seen things get worse in this country. So with that, I will wrap it up, and I'm happy to answer any questions.
Thanks so much, Joanne. Can I just ask the same thing that I asked Pamela? Is there a way that ordinary citizens can advocate or begin to try to combat this type of thing?
Well, you have to pay attention what's going on at your state with your state legislatures. Your local representatives always want to hear from you if you have a position on something. So, we have to stop these laws really where they're getting passed, and that is at the state legislature. So constantly, staying in touch with your legislative representatives, and certainly the same thing with regard to your congressional representatives. Let them know what you think. Tell them not to pass these laws. It can be very effective.
You mentioned the latest insurance crisis, and I've seen a lot in the news about issues with flood insurance in areas that are now in higher risk flood zone. Is that what you were talking about, or is that a different issue?
It's a little bit different because flood insurance, as many homeowners know who are in floodplains or have to face this, has to be purchased from the National Federal Flood Insurance Program. So what the homeowners policies cover is they will cover sort of hurricane damage, for example, but only wind and rain related. And then there gets to be big fights by adjusters and the companies themselves of whether they're going to pay a claim. If they argue that it's flood damage, they're not going to pay a claim, and they will fight you on that. But in Florida, what's happening is many companies are leaving Florida. They're abandoning the state altogether. And there's a terrible, this has been going on in Florida for as long as we've been paying attention, the hurricane problems. And there are solutions that Florida lawmakers are not considering about ways to force this industry to better cover homeowners in the state. Instead, what they're doing, and these are largely Republican lawmakers and DeSantis as governor, are, they're opting to do what the insurance industry wants them to do, which is to take people's rights away so that they can't even file claims against insurers for wind and rain damage. It's a terrible cycle that they're in down there. And it would be certainly, and we and others have proposed much better solutions to this than that.
Just a quick question about the finding contingency-based law firms, or those that are willing to take on contingent opportunities. I find it difficult to find those legal firms out there. Do you have any advice in terms of how you go about a search, other than looking at, you know, TV ads or billboards, things like that, where you can find reputable legal firms to offer contingent response?
Every state has a plaintiff's lawyer or trial lawyer association. Sometimes they're called like the trial lawyers of such and such state. Sometimes they're called like the Florida Justice Association. But they are the trade association of the plaintiffs' firms in the state. And I always suggest that people call their state, the state affiliated trial lawyer association that, you know, typically will be able to refer you to one of their members. I think bar associations generally also do that as well.
I was wondering, in view of what we're seeing with one of the hospitals across this country that had a huge informational hack, you've got a business in one state that controls all these hospitals in the other states. How does this play into the situation? Are the legal issues at one institution dependent only upon the state where that is, or do legal issues from state to state in this multi-hospital umbrella come into play in a different way?
That's a good question, and I'm not really an expert on how all of that works, but I will say that generally speaking, tort law is state law, and you will be governed by the law of the state in which the harm occurs. Now, there may be complications to that with regard to other types of issues, but when we're talking about just the straight medical malpractice law, that's a tort law, and that is governed by the state where the harm occurs. I don't know whether my other panelists have better insight into some of those legal issues, but I certainly defer to them on that.
Joanne, so this is Pamela. That's right. If on a personal injury, if it's a personal injury claim, there are some federal statutes that could come into play if you're suing a hospital. There are antitrust statutes that sometimes, because of these big consolidations, that have come into play. So it's not. It depends on what the claim is. But if it's a state law tort claim, they're going to figure out, you know, it's a choice of law that you have to go through in a litigation, what law is going to apply. And I think Joanne is right. Generally, it's going to be the law where the injury occurred.
I did have a question for Joanne. There are some studies that show that especially caps on medical malpractice suits disproportionately affected women. And I wonder, since women tend to vote more and are often, you know, more effective politically, to what extent can the sort of strategies against tort reform be framed as women's issues, and would that be an effective sort of way to go about it?
Well, you're absolutely right. There have been studies about this, particularly caps on economic damages have a disproportionate impact on women, children, seniors, and low-income people, because more of their damages tend to be non-economic in nature. But you know, in terms of the politics of this, I mean, it's a good point. I should point out that, and as Pamela remembers very well, when Congress finally did pass a product liability tort reform type bill, in the late 90s, and Bill Clinton vetoed this. He mentioned the disproportionate impact on women and others that this legislation would have. So he used it in his veto message, made a political point about it. I haven't seen it effectively used since then in terms of the politics of this issue, but it's certainly a very good point, and maybe there's more that we could do to let women know about how these types of laws hurt them in particular.
How do workers' comp insurance companies and that whole industry play into the picture?
Yeah, workers' comp is it's kind of a tragic situation what has happened. Workers' comp was something that was established in the early 1900s, essentially because it was very hard for employees, workers who are injured in the workplace to sue their employer. There are all kinds of doctrines on the book that kept them from suing. So states started trying to help them, and they passed laws, workers' comp laws, which set up systems where it was supposed to be no fault. All they had to do was show that they were injured in the workplace and they would get compensated. What has happened to these laws over the years is the insurance companies have lobbied to reduce these benefits and make it more difficult for workers in the long run. So benefits have been drastically reduced, and it's also very difficult often for workers to bring these claims at all now. So they stand, in they are not on the sort of same playing field that everybody else is that gets harmed through the negligence of others. The workers' comp insurance industry, as I said, has been very, very instrumental in pushing these limited benefits for workers. And they are part of the property casualty insurance industry. They are, a little bit separate because they're not part of the tort system, but they make the same arguments, basically, that, that there are too many claims, that we have to cut down on benefits, it's costing us too much money. It's the typical insurance industry crap, if you'll excuse my language, that
I'll allow it.
that we hear about, there are too many claims, we can't afford to pay these claims because we don't have enough money. And then you look at their their profit statements and the surpluses that they're sitting on, and their astronomical amounts of money. Again, people have to really dig into this data to find this and to push back, but it's a similar kind of fight we're in with workers' comp.
Thanks so much, Joanna. It was illuminating for sure. I would like to bring Ralph back for a few comments.
Yeah, thank you very much. I want to thank the panelists, Professor David Engel, tort practitioner Pamela Gilbert, and all-around civic advocate Joan Dorshow. Those of you who really want a tremendous website, including a study once of all the products that were improved that you buy in terms of their safety, or they were removed because they were too dangerous. There's a report by the Center for Justice and Democracy on that. And if you ever need arguments against the insurance companies or your politicians, Joanne has put out one study after another, debunking frivolous suits, debunking all kinds of myths that have been parlayed by the insurance companies and what we call the tortfeasors lobby, the corporations who don't want to be held accountable. Her website is centerjd.org. That JD meaning justice and democracy, centerjd.org. Now, there are millions of wrongful injuries every year in the United States, all the way from harmful bullying to toxic chemicals, workplace hazards, products that are dangerous, drugs, defective automobiles, flammable fabrics in the marketplace, and of course in the environment every day. And our founders foresaw that, which is why they gave us the Seventh Amendment and similar amendments in state constitutions, the right of trial by jury. And part of the subject matter today, the underutilization of tort law, reflects a severe decline in the number of jury trials, both at the state and federal level. This has been documented by New York University Law School Civil Jury Project, among other studies. So this precious right of trial by jury, which corporations like when they are plaintiffs, is drifting away from most people's consciousness. And that's why the public education function, which the American Museum of Tort Law embodies, has got to be widely expanded. The Tort Museum has a high school curriculum on tort law. There's no reason why high school students shouldn't learn about tort law. Even middle school students, they see a lot of auto crashes and their parents coming home sick from workplace exposures, bullying at schoolyards, and so forth. And all of the state trial lawyer associations have got to up their game and become much more educational. And there are about 60,000 trial lawyers in this country. If each one of them just spoke to small groups throughout a given year, you know, the social service clubs, high school auditoriums, if each one of them just spoke to 1,000 human beings, young, middle-aged, older, they would be reaching 60 million people in 1 year. And so there's a lot of important opportunities. The law schools should be even more educational here. This is a very precious right. It's part of our democracy, a critical part of our democracy. Protection of our health and safety, compensating for wrongdoing, deterring further practices by the perpetrators, and publicly disclosing defects like the opiate defects or the car model defects or different brand names, you know, that come out of the courtroom or the discovery process by trial lawyers way before they are considered by state legislatures, congressional hearings, or regulatory agencies, which the law of torts and court cases nourish. You had cases involving unsafe tires years ago in the 1960s. There were lawsuits against tire companies. It showed inadequate testing. It caught the attention of Senator Gaylord Nelson. He started putting legislative activities in the Congress. It led to the federal tire safety law because the evidence came out of these court cases and these depositions. The two greatest attacks on the tort system are these fine print contracts that Pam Gilbert pointed out, where all these courts rule so often against the injured party because they say, hey, you know, on page 38 in this fine print contract, you agreed to compulsory arbitration, so you consented to it. What are you bothering us for? And the people don't even read those contracts. Sometimes you can't even get copies of the contracts. Law professors can hardly understand these contracts. The Airbnb contract with homeowners, the one I saw, 68 pages of fine print. You need a microscope. So contract law, which is supposed to be for the people, has been turned into a cannibalistic force on tort law. And the other attack comes from the legislatures, the politicians who get all these campaign contributions from the insurance companies and chambers of commerce and others. People often don't realize it is very hard to win a tort case in court. It comes up against the power of these corporate law firms who are really part of the problem big time in crushing the rights of people across the whole spectrum of democratic rights, not just tort law. And they can delay. They're not required to pay any medical bills. They deduct the expenses, the companies who hire these corporate law firms. and the plaintiff lawyer is not getting anything because the contingent fee and time is of the essence, and they delay, and wars of attrition, delaying motions, filing frivolous motions against the wrongfully injured person, and then the plaintiff has to get the jurors to agree. And in most states, it's unanimous agreement. Some states, it's not unanimous, but that's not easy either. And then the corporate defendant can appeal, or the insurance company can appeal and force an even less satisfactory settlement. So anybody who thinks, like the insurance company fake cases and propaganda, that you get injured, you get your thumb cut and you wave it before a jury and they give you $1 million, it's totally false propaganda. The insurance companies like Aetna and Cigna and others ought to be ashamed of themselves historically and at the present time. The idea of successful tort cases is very simple. If you require the wrongdoer to internalize the cost, let's say corporations flooding your neighborhood with pollution, contaminating drinking water, selling you addictive drugs without adequate disclosure, if they have to pay, that means they have to figure out, well, is it cheaper to be safe and not have to pay these verdicts and higher insurance rates, or is it cheaper to injure people? Well, if they don't have to pay, it's cheaper to injure people, which was the case in the 19th century in the railroad industry, among others. So that's the idea. And some people will say, well, if all these millions of people file suits, it's going to flood the courts. It's going to clog the courts. Well, first of all, the more successes of these suits, the more careful perpetrators are going to be. And the word starts spreading, hey, you can't negligently or criminally injure people and get away with it. So they clean up their own act. The second is, we don't have enough budgets for the courts that are needed. What are we rationing courts for? The average court budget in states around the United States is 2% of the state budget. So the state budget goes to all kinds of executive programs, agencies, departments. It pays for the legislature, 2%. That is far too small. There should be more judges, more facilities to handle just claims by the American people. And the more they learn about this, the more they're going to use it. For example, we've heard a lot about police brutality in the last few years. Excessive use of force, illegal, people being killed, many of them minorities, and the grieving parents try to get justice. They try to get the prosecutors who go to work every day near the police department. They try to get the prosecutors to prosecute the police. And in a vast majority of the cases, they either don't prosecute or the police get off. Well, what these families have learned is that these crimes of police brutality are also torts. A lot of corporate crime is basically a tort. And so they got a tort lawyer to sue and settled for millions of dollars in some of these cases. They would sue the municipality, which has to pay for the police department's excessive violence. And they used tort law for a measure of justice. They could never bring their loved ones back, but at least the cities realize they're going to have to pay higher insurance rates, and maybe they better rein in some of their more aggressive police people in their department. The other thing that's coming on the horizon is more and more corporate abuses, crime, torts are remote. They're hard to define causation, as Professor Engel has pointed out. As technology expands, it's not just it's hard to trace it to a certain chemical in the drinking water or to a certain defect in a complex a machine in a factory or in the motor vehicle industry, you now are exposed to artificial intelligence, which is increasingly susceptible to being sued under tort law. Major studies now on how it's harming young people. These algorithms and Facebook and Instagram and TikTok marauding of our youngsters. Nanotechnology, biotechnology, all kinds of new technologies they're developing that are really hard to trace in terms of causation. And so it's all the more important for tort lawyers to become more educated themselves about these so they can bring these groundbreaking lawsuits. The other thing that's important, and we've all had this experience with people, they get injured by a doctor, and it's their doctor. And the doctor makes a mistake, punctures a colon, say in a colonoscopy, and some of them may apologize. Sometimes there are medical artifacts left in the cavity of the patient, and the patient doesn't even know about it. Why doesn't the patient sue? Well, they don't want to sue their doctor. They've been their patient for a long time. Everybody makes mistakes. But see, if they had a larger grasp of what's happened to them and what the society provides, they'll say, well, I'm really not suing my doctor because the insurance company covers for the doctor. So that's what insurance is all about. So if you have positive feelings toward anyone who's perpetrated harm on you, oftentimes these perpetrators are insured. We're not talking about street criminals, but in the business world, they're insured. And that's what people should realize, that they could get a settlement, and there wouldn't have to be a trial. When you puncture a colon, it's pretty much what the lawyers call res ipsa loquitur. The thing speaks for itself in terms of liability, strict liability. One of the questioners mentioned the famous Johns Hopkins School of Medicine report of 2016, which said, as a conservative estimate, 5,000 people a week die in hospitals from what the physician authors called preventable problems, end quote, preventable problems. Well, a lot of those preventable problems are outright negligence or downsizing the number of nurses. They couldn't service the patient and bad things happened, for example, or simple incompetence, or what are called accidents. And the vast majority of next of kin never even see a lawyer. And so there's not enough internalization of costs by the hospitals and the insurance companies who don't do enough loss prevention. They should be doing a lot of loss prevention, setting stricter standards and inspections of hospitals. But at any rate, when you see that figure, 5,000 a week, that's just the fatalities. What about the injuries? People who survive bad treatment in the hospitals, negligence, incompetence, and carelessness, and inadequate staffing. So we want to keep our eyes on all these things as we become active citizens and really get underway here and fight for the health and safety of present and future generations. Couple other things. The new technologies here and the discovering of old technologies that we didn't think were harmful are raising a specter of these wrongful injuries going out of control. And I'm referring, for example, to the chemical industry. The vast majority of chemicals and their combination with one another isn't really regulated by the EPA. They can't keep up. The budgets are too small. There are too many times you have Trump-like presidents who shut the agencies down. And we now see PFAS in drinking water. That's been widely publicized. We see microplastics everywhere that are in all our bodies now, microscopic bits of plastic from the water we drink or the food we eat. So I think as epidemiologists start discovering more and more of these latent injuries, the challenge to tort law is going to be even greater. And so we need more tort lawyers. Robert Falmouth, professor of law at the University of San Diego Law School, has written about the inadequate number of lawyers. This may seem strange to a country that has more lawyers per capita than most other countries in the world. But if you don't have enough lawyers, you don't have enough representatives of just cases and just outcome. And there's got to be more lawyers, and the system has to be more easily accessible than it is now. I think all high school students should go visit courtrooms. They should sit in the courtroom. Even middle school students. They shouldn't just go to Disneyland or some museum, although they should go to the American Museum of Tort Law or have access to it virtually anywhere in the world. But the courts are often seen as cold, austere institutions that are unfriendly and unknowing and unfeeling. And we've got to break that barrier down. Even small claims courts where you can go without a lawyer, people are afraid just to step in to the building. And the courts are there to serve you. Way back before the American Revolution, people used the courts a tremendous amount for all kinds of business. Farmers used it, people used the courts. One of the reasons for the revolution was that King George III was restricting their right of trial by jury and their right to go to court. And we've got to recover that. There's absolutely nothing more American than seeking justice for your redress of wrongdoing and harm done to you, your family, your neighbors, and community. Now, last thing I want to point out is that when you meet politicians and they want to get your vote and shake your hand, ask them about where they are in civil justice and tort law. I talk to state and federal legislators. They often say, we never get any feedback on that. You know, you say we should care about it. We hear from the insurance companies, but we don't get any feedback. Well, people should feed back. They feed back on street crime, and street crime, by the way, is also a tort. It's not just a crime. And they should feed back on these things. There are awful injuries to our children by wrongful deeds, inadequate nutrition, junk food, hazardous toys, things that you never consider would harm children, negligent daycare centers, and so forth. And we should not forget the protection that they deserve from their elders. So go to centerjd.org. centerjd.org. In my view, the most educational, clear-eyed website on tort law that there is in the country, and encourage you and your neighbors to take a 1-hour free tour of the American Museum for Tort Law, which is very educational. And you can go through all the exhibits of all the great cases in the past, the tobacco cases, the asbestos cases, the workers' injury cases, all kinds of cases with great artwork and describing each one of these cases. So you see what a heritage we are inheriting and how we have to preserve it and expand it for future generations, or what our founders called posterity. Over to you, Melissa.
Great. Thank you so much, Ralph. I hear that there is a question for you in our audience.
First, I do want to say how much I greatly appreciate this wonderful session today, opening our eyes to the many, many merits of our civil justice system, if only it is utilized and protected by we citizens. My question has to do with if there is a wrong that is done or is planned to be done, such as deconstructing and then rebuilding a concrete highway, which will generate huge amounts of crystalline silica construction dust that will give our children and our adults asthma, silicosis, COPD, and cancer, lung cancer. Can we file a tort action to prevent this kind of deconstruction of the concrete roadway that will generate all of this harmful silica construction dust that will give injuries to the children and adults over the next 4, 5, 6 years or so after the project has released all that silica dust into the air that we must breathe? Is there a tort action that can be utilized to prevent this from occurring?
Well, this is an actual case, viewers, in Maryland that's going on, and the citizens have so far blocked it. There is a tort case that can be brought once the harm occurs against the contractors, the private contractors for the state of Maryland, but it cannot be brought before the harm starts to occur. Tort lawsuits against governments are really difficult if the governments try to say they're sovereignly immune. The king can do no wrong, going back centuries. There is a federal case that allows tort lawsuits against federal government. For example, defective military equipment that kills soldiers, helicopters, for example. Those can be maneuvered, but they're pretty hard. The governments like to shield themselves just like the corporations do. So you would have to wait until there was evidence that there was a tort, there was harm that was inflicted. So that's not enough to stop the project. The project has to be stopped by other forms of litigation and lobbying the state legislature, as I'm sure you and your citizen groups have done over the last several years.
Hi, everyone. Thank you to the Museum of Tort Law for this important event, and thanks also to the esteemed panelists for this valuable information. My first question is, I'm considering exercising my rights as a consumer in small claims court, but I'm not a lawyer. Do the panelists have any advice about initiating this process and pursuing major corporations in small claims court? And how conversant in the law does one need to be in order to have success against a major corporation in small claims court?
Well, that's a very good way to go after these corporations. Every state has small claims courts. They're usually next to the Superior Court. Sometimes they're open in the evening, so people work during the day can use them. They were designed originally to be used simply, without a lawyer. Just go in, you make your claim, and if the defendant wants to oppose it, the defendant is noticed, of course, and can make a counter argument. And then the judge often makes the decision right away, like the program on TV. There are two problems here. Because people don't understand much about using small claims court, it's not taught in our elementary and high schools, as it should be. They don't rush to protect it. As a result, more use of small claims courts comes from landlords against tenants instead of tenants against landlords, and creditors against debtors. So it's been turned upside down to be used against consumers and workers and patients instead of the reverse. However, that doesn't mean you can't use it. You just got to learn to want to use it. And the nice thing about it is that if you sue a large company for, say, $2,000, $3,000, the total amount you can sue is rarely above $15,000. That's the cap. In some of the states, it's $5,000 in small claims court. The corporation may not even show up. They don't want to pay a lawyer several $100s an hour to show up. So you get a default judgment against the corporation. And then you've got to collect it, of course. But there are manuals on how to use a small claim court all over the place. There's one put out by Public Citizen years ago called Representing Yourself, What You Can Do Without a Lawyer, which I was pleased to introduce. And they have a chapter on small claims court. But if you call the small claims court, they have a nice pamphlet online giving you step-by-step instructions on how to use it. And I think it should be used more against these big companies. And it would make news as well. And I hope the law school clinics will engage small claims in a more coordinated way around the country. So if a bank is cheating people everywhere in the country like Wells Fargo was, it can be sued in small claims court. Now, in some areas, there's federal preemption, and you can't sue in a state small claims court. But by and large, it's wide open for utilization.
I want to take this opportunity to thank all our panelists. It was very, very interesting and important. And I want to thank our viewers for taking out the time today. I feel like it's a conversation that probably should be continued at a later date. It's crucial to understand why, despite the presence of a legal framework, many individuals refrain from pursuing legitimate claims. And as we've heard today, there are a complex web of reasons that deter people from seeking the justice and compensation they deserve. Hopefully today has shed light on some of the barriers that often prevent individuals from engaging in legal action, and highlighted the untapped potential of tort law in addressing a multitude of grievances and promoting accountability. I would also like to say, please visit our website, which again is www.tortmuseum.org. And if you happen to be in the northwest corner of Connecticut, we are located in Winsted, Connecticut at 654 Main Street. Please stop in for a tour and have a great rest of your Saturday afternoon.